For the first time in living memory, the United States Department of Justice didn't just whisper from the sidelines of a Second Amendment showdown. It stormed the field, not with a memo, not with a carefully phrased amicus brief, but with a full-throated argument against Illinois' so-called assault weapons ban. Think about that. A branch of the executive government standing in a federal courtroom, shoulder to shoulder with gun owners, declaring that freedom is not negotiable. That is not business as usual. That is history in motion. Picture the scene in Chicago's 7th Circuit courtroom. At the lectern, Assistant Attorney General Harriet Dillon, the head of the Civil Rights Division, isn't there to make friends. He's there to say something blunt. Illinois cannot outlaw arms that millions of Americans already own, rely on, and use daily for lawful purposes. This isn't about exotic, military-only weapons locked in some armory. This is about the rifles you see on the range, the magazines in your safe, the very tools families trust for defense, sport, and hunting. When the DOJ puts its weight behind that truth, the political earth shakes. The message is clear. The Second Amendment is not a second-class right. Illinois politicians tried to spin their sweeping prohibition as safety, signed by Governor J.B. Pritzker. The law criminalizes standard capacity magazines and semi-automatic rifles, the exact kind of arms that millions of law-abiding Americans own. The same rifles used in competitions, the same rifles trusted for home defense, the same rifles passed from father to son for hunting season. But Illinois slapped the label assault weapon on them and told the people, surrender what you own or become a criminal. That's not safety. That's confiscation in disguise. The timing couldn't be sharper. In 2008, the Supreme Court in District of Columbia versus Heller made it plain, the Second Amendment secures an individual right. A right unconnected to malicious service. A right to keep arms in common use for lawful purposes, above all self-defense. And then in 2022, the court in New York State Rifle and Pistol Association v. Bruen drove the point home. Modern restrictions must line up with the nation's historical tradition of firearm regulation. If the state can't prove it with history, the law doesn't stand. That's the test. That's the yardstick. And Illinois fails on both counts. Here's the raw truth. The rifles and magazines targeted are not rare, not unusual, not exotic battlefield trophies. They're the everyday, ordinary arms of the American people. Bruen says regulation must find historical analogs. Show me where, in early America, entire categories of commonly owned arms were wiped off the map. Show me where citizens were told, these muskets are too scary, you must hand them in. You won't find it. Illinois is making it up, and the DOJ, for once, has the guts to call it out. The stakes are bigger than Springfield or Chicago. This is a test case that will ripple from coast to coast. Every governor in a ban-happy state, California, New York, New Jersey, Massachusetts, is watching. Because if Illinois' law collapses, their house of cards collapses with it. And if Illinois' law survives, you can bet those states will sprint to write even harsher bills, pointing back to Chicago as their shield. That's why this fight is the fight. This is about whether the Second Amendment stands tall or gets trampled flat under political boots. Inside the courtroom, three paths lie open. The judges could strike down the ban entirely, a clean, powerful statement that Illinois cannot criminalize arms in common use. They could play Solomon, carving out a partial ruling that muddies the waters and keeps citizens guessing. Or, worst case, they could rubber stamp the ban, pretending that weapons of war language overrides precedent and plain text. No matter the outcome, one thing is certain. The path ends in Washington. The Supreme Court won't sit this one out forever. When civil rights are on the chopping block, the High Court takes the final swing. And that's what makes today historic. For decades, the DOJ sat silent, or worse, defended restrictions. Now the same institution is standing in the breach, telling judges, telling lawmakers, telling the country, the Constitution is not negotiable. That sound you hear isn't just another legal argument. It's the starter's pistol in a battle that stretches far beyond Illinois. The fight is on, and the ripple effects are only beginning. If Illinois' ban crumbles in that Chicago courtroom, the aftershocks will rumble across the entire country. Imagine the chain reaction. California lawmakers forced to rethink their entire arsenal of restrictions. New York legislators watching their decades-long assault weapon bans hanging by a thread. Massachusetts, New Jersey, and Connecticut suddenly staring at legal quicksand where they thought they had concrete. When one domino tips, the whole line starts to fall. And if Illinois falls, that collapse will be heard in every state house from coast to coast. This isn't a small skirmish. This is a battlefield where the federal government is now standing shoulder to shoulder with citizens, and that's what changes the game. Up until now, state politicians have counted on private citizens or advocacy groups to fight these lawsuits. Groups like the USCCA, the FPC, or the NRA. They figured they could outspend, outlast, and grind down the opposition, but today is different. Today, the Department of Justice is saying, you are not just fighting against gun owners, you are fighting against the Federal Civil Rights Division. That flips the script. That raises the political costs sky high. Think about the chilling effect this sends to lawmakers. Draft a sweeping ban tomorrow, and you may not just face private lawsuits, you might face the Justice Department itself saying, enough. That is not just a legal threat. That is a political thunderclap. Because even for anti-gun politicians, there's one enemy they fear more than grassroots groups, and that's Washington's lawyers coming at them with the Constitution in their hand. Now, let's be real about the courtroom options. The best case scenario is a clean strike. The judges slap down the Illinois law and declare, flat out, that semi-automatic rifles and standard magazines in common use cannot be banned. That ruling would be nuclear. It would slam the brakes on every other state trying to roll out copycat bans. It would be the knockout punch the Second Amendment deserves. But the nightmare scenario, the judges buy into the weapons of war narrative. They side with emotion over law. They uphold the ban, pretending Heller and Bruen never happened. That outcome would not be the end. It would just kick the fight up the ladder. The Supreme Court would have no choice but to step in. But in the meantime, hostile legislatures would sprint ahead. They'd write even more aggressive bans, pointing back to Illinois as their legal cover. Citizens in those states would be left scrambling, caught between unconstitutional laws and the slow grind of appeals. And then there's the middle path, the so-called compromise. Judges carving up rights with a scalpel, saying, well, magazines are protected, but rifles are not, or this feature is fine, but that one isn't. That is not clarity, that is chaos. Imagine being an owner trying to figure out whether the rifle in your safe today is contraband tomorrow. Imagine a patchwork where one court says a 1301 shotgun is legal while another bans it outright. That's not rule of law, that's legal quicksand where every step sinks you deeper into uncertainty. The anti-gun lobby will paint this as necessary for safety. They will wave pictures, scream statistics, and call these rifles weapons of war designed only for carnage. But here's the truth they never admit. Criminals do not obey bans. They never have. They never will. The only people punished are the law-abiding, the father who keeps an M4 platform rifle for home defense, the young woman who trains with her AR at the range every weekend, the hunter who passes down a semi-auto rifle to his son. Those are the people Illinois is criminalizing. Those are the people standing trial in spirit today. And here's the twist that should make every American pay attention. This fight is not just about rifles and magazines, it's about precedent. Once you accept that a state can redefine common use firearms as contraband, what's next? Shotguns with 7-round tubes, handguns with threaded barrels, optics, accessories? Where does it stop? The moment you let politicians dictate which tools are too dangerous, freedom becomes a permission slip. And permission slips can be revoked. That's why this case is not just another headline, it's a turning point. The DOJ's involvement tells us the executive branch is done playing footsie with gun rights. They've stepped into the arena, and once they're in, lawmakers everywhere will think twice before rolling out another sweeping ban. The political map is changing. The question is, will the courts honor the Constitution, or will they gamble with liberty? Stay with me, because what happens next could determine the future of the Second Amendment for generations. Now let's talk about the storm clouds that roll in if the Seventh Circuit goes the wrong way. Picture this nightmare. The judges rubber stamp Illinois' ban. They buy the line that semi-automatic rifles are weapons of war and pretend the Constitution bows to political fear. That ruling would light a fire under every anti-gun legislature in America. California, New York, Massachusetts. They wouldn't just double down, they'd sprint ahead with harsher bans. They'd point back to Illinois and say, see, the courts upheld it. We're clear to crush even more rights. That's the avalanche waiting to roar downhill if this panel gets it wrong, but don't lose hope. The Constitution is not on their side. Heller already smashed the idea that the Second Amendment is tied to militia service. Bruen already demolished the discretionary licensing game. And the same principles that killed those arguments will cut down sweeping bans on arms in common use. If the Seventh Circuit trips, the Supreme Court is waiting. This fight is not just Illinois' fight, it's the people's fight. And the highest court has the last word. Critics will scream that banning these rifles saves lives. They'll wave charts and cry that statistics prove the need for bans. But here's the reality. The evidence is thin, contested, riddled with loopholes. Even researchers admit assault weapon bans have murky results. What isn't murky is the Constitution. The Bill of Rights doesn't say, shall not be infringed unless it makes politicians nervous. It says what it says. And millions of Americans exercise that right responsibly every single day. Think about it. Criminals ignore bans. They always have. Prohibition doesn't touch them. It only shackles the law-abiding, the veteran who keeps an AR platform in the closet for defense. The mother who carries a 380 ACP for protection. The competitor who trains with a 357 Magnum at the range. These are the people Illinois is targeting. Not criminals, not gangs. Ordinary, honest citizens who follow the law. That's who gets punished when bans pass. That's who gets turned into criminals by the stroke of a pen. And let's be clear, rights do not vanish because politicians whip up fear. Freedom isn't a mood ring that changes with public opinion. Rights are rights, period. The Second Amendment is not a suggestion. It is not negotiable. It is not something lawmakers can trade for headlines and campaign checks. When the DOJ stepped into that courtroom in Chicago, it wasn't just about one law. It was about drawing a line in the sand and saying the Constitution is not for sale. So what do we do from here? Number one, stay informed. Most Americans have no idea this case is unfolding right now. Share this video, spread the word, get the truth into living rooms across the country. Number two, get involved. Support the organizations carrying these lawsuits. Skip the pizza, skip the six-pack, and put that $20 into defending your rights. Litigation funds win battles, not hashtags. Number three, use your voice. Social media, emails, conversations at the range. Every voice matters. Every push counts. This is bigger than politics. This is freedom. Plain and simple. The Department of Justice showing up is unprecedented, historic, massive. It is a warning shot to every lawmaker who thinks the Second Amendment is up for negotiation. The message is crystal clear. Freedom is not optional. It's not conditional. It's not secondary. The Second Amendment is the backbone of American liberty. And tonight, as the echoes from that Chicago courtroom roll out across the nation, every gun owner, every freedom lover, every patriot needs to hear it loud and clear. Stay safe, stay armed, stay free.